is not forgiving on these things right now at all. So it is really important to hit these deadlines.
Right. So far, I've been lucky, thank goodness. But anyway, yeah, we really do need to be conscientious. So we talked around this issue a moment ago, but who is responsible for being sure the administration of a retirement account is handled in a timely manner?
I'm so glad you bring that up, Mike. I mean, as you can tell as I'm talking about it, it's a bit confusing about who's doing what. You know, as an attorney representing the successor trustee or the executor, my client comes to me and says, well, there's this $1.5 million IRA and it named the 3 kids as the beneficiaries, and what do I do about it? And I said, well, you let your siblings know. You let the beneficiaries know, because you as the trustee, you can't collect it. Yeah. You don't have that authority. Now, oftentimes, that being said, so it is the short answer to your question. Sorry, I'm a lawyer. I talk around it. The short answer to your question: it's the beneficiary's responsibility.
Yeah. So, okay. So you have to know about your own. The accounts that you're beneficiary for, and you might not know.
And you might not know, and the attorney's not going to take responsibility for it. The CPA is not taking responsibility for it. The plan administrator is not taking responsibility for it. The beneficiary doesn't know about it or about what needs to be done about it. So practically speaking, what happens in most circumstances, again, the responsibility is the beneficiaries, but what happens in most circumstances is that, say I'm representing the trustee will come to me and think that they're responsible for it, and what we'll do is the trustee, on behalf of the beneficiaries, might contact the account holder, the custodian, whether that's Schwab or Fidelity or whomever has that IRA account, and the trustee knows about it because the trustee handles the finances, and get them in touch with the beneficiaries of the account and make sure that the process gets started.
Right. So some of these things we do out of courtesy or whatever. In other words, we want, you and I would say, because we're familiar with these things, we want things to go as smoothly as possible for the family. And so we do. We say, you need to contact the beneficiaries. We may write to the beneficiaries. You need to contact, we found out about this IRA account and so forth.
Exactly.
You need to contact the bank. You may need your own attorney.
Exactly. Exactly. And that's that's the letter that comes out of our office. If we're doing a letter, we'll send it to the beneficiaries and let them know that we believe you're a beneficiary of the account, or the account holder has notified us that you are a beneficiary. Here's their contact information. It's your responsibility to follow up with it. And if you think you need legal advice, you should see your own attorney, as I am not your attorney. I am the attorney for the trustee.
Okay, well, we need to chug along here. So, a lot of times when we make the beneficiary designations on these accounts, we'll list, for example, I may list my children, and then if my child has deceased, maybe I'll list my grandchildren.
Correct.
So they're a contingent beneficiary if my child does not outlive me. What happens when I pass away? Now, my child is going to inherit their share of this IRA. Let's say they're taking out their payments in installments. Will my grandchild still automatically be the contingent beneficiary?
No. Here's the interesting thing about these accounts. So these IRA accounts, these are supposed to be retirement accounts to sustain the participant. That's what the designation in the code is, the participant, the owner, the person who contributed. It's meant to be used during their lifetime. So if the participant dies and they happen to have money left in their account, as most of them do, whether it's $10,000 or $1.5 million, then that account goes to the beneficiary. Now, what I'm going to recommend to the beneficiary, if it's a significant account, is they don't withdraw the funds, but they transfer title of that account. So instead of being dad's IRA, it's dad's IRA for the benefit of son.
Yes.
And so it's a new account. It's not taken out of the IRA, so you're not paying the taxes on it. Right. It's a new account. It's administered during the beneficiary's lifetime. They are required to take out minimum distributions, even if they're not 70 and a half yet. Even if you're 5 years old, if
Yes.
you've inherited an IRA, you start taking distributions by December 31st of the year after the decedent died. But when you take that account and it becomes an inherited account, the contingent beneficiaries that were originally named no longer have an interest in the account.
Right. Okay. Okay, so here's a good one. What is the required minimum distribution, and why is it important for an inherited retirement account? I think we talked a little bit around
We've
this
touched
before.
on this.
So what difference does it make if the beneficiary to the account is a surviving spouse?
Okay, so typically for everybody but the surviving spouse, they are going to take the account as an inherited IRA, and as I indicated, the beneficiary of an inherited IRA starts taking distributions basically immediately, okay? Doesn't matter if you're 89 years old or 29 years old or 9 years old. You start taking those distributions immediately. The minimum amount you can take out and not get hit with penalties is based on the value of the account and your actuarial life. So they do a computation based on the beneficiary's age to make that account stretch out for the beneficiary's lifetime. That's the goal. And so you'll start taking those distributions. The minimum amount you can take out is called the required minimum distribution. That's the least amount you can take out and not get hit with penalties. You can take out more, but you can't take out less without paying those 50% penalties on the amount you didn't take out.
Right.
All right. If you're a surviving spouse, you can roll that account over into your own IRA. That is the difference. If I, at my age, my spouse died and I inherited his IRA, instead of taking it as an inherited IRA where I would have to start taking money out now, I could roll it over into an account that was my IRA. It's not an inherited IRA anymore, it's my IRA. And once it's my IRA, I can wait until I'm 70 and a half to take distributions.
Right.
So the benefit is that I can keep it in there longer because I don't have to take the distributions, and I'm going to get more of that tax-deferred growth, right? The disadvantage is if I'm younger than 59 and a half, and if I need some of those funds because I've lost the other breadwinner,
Right.
I've got a real problem. So if I've rolled it over and it's in my own name, now it's subject to all the regular IRA rules, and if I'm not 59 and a half yet, I can't take out that money without that 10% penalty kicking in addition to the income tax.
Right.
So if I'm a younger spouse, I probably don't want to do that rollover. I got to really look at my financial situation. Again, this is why you go and talk to your attorney or you talk to your CPA to get some guidance so you understand the benefits of doing the rollover, which is you can really stretch out and get more of the tax deferral. But the disadvantage is that it's going to lock the money up, and if you need it, you're going to have to pay extra to get it out.
Right.